Hi, this is Eric Cohn, executive producer and host of Act in Line. And before this week's episode, I want to briefly tell you about our upcoming Poverty Cure Summit, an Acton Institute event. The Poverty Cure Summit is a premier digital experience. You'll have the opportunity to hear scholars, human service providers, and practitioners address the most critical issues we face today, which can either exacerbate or alleviate poverty. With conversations rooted in foundational principles of anthropology, politics, natural law, and economics, you'll gain a deeper understanding of the root causes of poverty and identify practical means to reducing it and promoting human flourishing. Featured speakers include Amity Schlaze, Anthony Bradley, Philip Booth, Isis Brantley, Peter Greer, Mauricio Miller, Ann Rathbone Bradley, Jay Richards, and many more. The Poverty Cure Summit will take place November 18th and 19th, virtually, so you can join from the comfort of your living room. Registration for the Poverty Cure Summit is $99, but if you visit povertycuresummit.org right now and enter the discount code ACTINLINE, all one word, at checkout, you can register now for only $49. Just enter the discount code ACTINLINE, all one word, at checkout. Your Poverty Cure Summit registration includes access to main stage sessions, a diverse range of panel discussions with experts and practitioners, interactive question and answer sessions with our panelists, and networking opportunities with summit attendees. Join the conversation and be a part of the cure. To register or learn more, visit povertycuresummit.org. That's povertycuresummit.org today. Welcome to Act in Line, the podcast of the Acton Institute for the Study of Religion and Liberty. I'm Eric Cohn, executive producer. On October 14th, 2020, the New York Post published an expose on former Vice President and current Democratic presidential nominee Joe Biden's son, Hunter Biden, headlined, "Smoking Gun Email Reveals How Hunter Biden Introduced Ukrainian Businessman to VP Dad." Shortly after the article's publication, the ability to share the link to the story was limited and, in some cases, prohibited by Facebook and Twitter, with those social media companies alleging that the content was unreliable, unverified, or was prohibited for containing hacked information. This incident has provoked the latest round of calls for reform or repeal of Section 230 of the Communications Decency Act of 1996. The U.S. Senate has subpoenaed Facebook CEO Mark Zuckerberg and Twitter CEO Jack Dorsey to appear before a hearing to examine the New York Post incident. Senator Ken Buck, Republican of Colorado, said, "Condemnation is not enough. It's time to reform Section 230. Senator Ted Cruz, Republican of Texas, called Section 230 a gift and a subsidy from the taxpayers to big tech. And Senator Josh Hawley, Republican of Missouri, has introduced legislation that would allow Americans to file lawsuits against big tech companies who breach good faith user agreements by censoring political speech or suppressing content. What is Section 230? What does it actually say? What role did it play in creating the modern internet as we know it? And what would happen if it were changed or repealed? Today, I'm joined by Scott Lincicome, an international trade attorney and a senior fellow in economic studies at the Cato Institute, to discuss the issues surrounding Section 230. You can find additional resources in the show notes for this episode, as well as find previous episodes of Act in Line on our website at acton.org/actinline. And if you like this program, you can help us reach even more listeners by sharing it with a friend and leaving us a 5-star review on Apple Podcasts. We welcome your comments as well. Act in Line is available on Apple Podcasts, Google Play, Spotify, Stitcher, or wherever you listen. Scott Lincicome is an international trade attorney, a senior fellow in economic studies at the Cato Institute, and a visiting lecturer at Duke University Law School. He also writes the newsletter Capitalism for the Dispatch. Prior to joining Cato, Scott spent 2 decades practicing international trade law at White and Case LLP, where he litigated national and multilateral trade disputes and advised multinational corporations on how to optimize their transactions and business practices consistent with global trade rules and national regulations. Scott Lincicome, welcome to Act in Line.
Oh, thanks for having me.
So let's start real basic here. What is Section 230 of the Communications Decency Act of 1996, and how did it come to be?
Right. So Section 230 is a law, obviously, that relieves internet companies from a lot of legal liability with respect to the content that third parties, basically you and me, people who aren't employed or affiliated with the actual internet company, with the content that we put on their websites. And the reason 230 came about was what became known as the Moderators Dilemma. And the Moderators Dilemma arose out of a series of court cases in the 1990s. Essentially, you had one series of court cases that held that websites that do not moderate content, so they just simply let anyone throw up anything, no matter whether it's legal, illegal, or whatever. They just let no moderation at all. The courts ruled that those websites were not liable for the things that third parties placed, that content that third parties placed on their websites. Now, another series of cases ruled much the opposite, but with a hitch. They said that companies that do moderate content, so for example, let's say they pull down pornography from their websites. If you moderate content, the courts were finding that they were liable for anything put on their websites by third parties. And this arose primarily out of defamation cases. So people were suing these websites for false statements, slanderous statements about them that were placed on these websites. So Congress realized that this Moderator's Dilemma was really creating a rather perverse incentive for websites, essentially penalizing them for moderating content. And essentially saying that, look, if you actually act in a good manner by pulling down illegal or defamatory or whatever stuff, you are liable. So that, of course, it incentivizes them to not moderate at all, right? Which really would just turn the internet into even more of a cesspool than it already is. So Section 230 was then developed in the mid-90s to solve the Moderator's Dilemma. And it does really two very simple things, contrary to what you might read. Very simple things. It is both a shield and a sword. The shield really just says that any website shall not be treated as a publisher or a speaker, and thus be liable for content placed on the website by third parties. So in other words, hosts in any website, social media, Amazon, Yelp, Netflix, the New York Post, you name it, any website will not be liable with a couple exceptions, for example, for child pornography or stuff like that. Will not be held liable for any third-party content placed on their website. So that's the shield. That's all it says. Now, the sword. The sword is similarly simple. It simply says that companies also will not be held liable on account of their good faith efforts to moderate any content that they deem to be objectionable. And that's really a key point here. And it's that because it is purely in the subjective opinion of the private business. It is what they consider to be objectionable. And that could be obscene, lewd, violent, harassing, any way that they deem to be objectionable, they can moderate it and they won't be liable for those moderation activities. That is their sword. And so basically websites can remove third-party content without liability, that you can't sue them for removing your posts, deleting your tweets, whatever. And that's even if that content is protected speech. So it's protected by the First Amendment. So that's it.
So this provision, the Section 230, has been called by some really what the clause that launched the modern internet. That in 1996, if we think about it in terms of the time, that was when you'd get CD-ROMs in the mail from AOL, or you access the internet through CompuServe and these far more gated systems.
Right.
And that 230 opened up really and created what we have today and know as the internet. Is that accurate?
Yeah, I think that's very accurate. In fact, there's a book out there called The 26 Words That Created the Internet, all about how Section 230 really fueled the growth of what we consider to be modern internet business. And again, not just social media. Of course, social media is a part of it, but really any sort of online business. And if you look at the data, you see that both internet publishing and broader information communication technology really grew exponentially over that period, almost a 10-fold, 9.5-fold increase since the mid-1990s through 2019. And really is just a massive industry today. You know, as I noted in the newsletter, internet publishing alone is about 4 times as big as the entire metals industry. So, you know, we're all worried about the steel industry and the aluminum industry here in the trade world. Well, internet publishing alone is 4 times as big as that industry. And of course, employs hundreds of thousands of workers and the rest. Now look, there's no doubt that technology played a huge role as well. Smartphones in particular, just internet speeds, the quality of tech, certainly important. But experts pretty uniformly agreed that tech said that without Section 230, we wouldn't have seen this explosion of business because, quite frankly, companies would have been terrified of trying to police third-party content. And quite frankly, a lot of websites, and again, not just social media, but certainly social media, really couldn't exist without third-party content. I don't know about you, but when I want to buy something on Amazon, really the first thing I do after finding the product is go check the reviews. And if you can't have those reviews on Amazon or Yelp or whatever, those companies are really going to have a hard time existing. And so, Section 230 played a really big role there.
So the context that we're talking about this in the most recent incident that has fueled this conversation was Twitter and Facebook's treatment of a New York Post story on Hunter Biden in the context of the election. But it's not the first time that Section 230 has been raised over the last couple of years. It has come up with regard to Twitter placing warnings on President Trump's tweets, decisions to block certain content. You have Facebook's decision to add a fact-checking element to what content that they allow. Yep. Prior to, let's say, the last 4 years or so, had Section 230 really, I don't want to say flown under the radar because it had clearly been given this credit of creating the modern internet, but had it drawn anything relatable to the ire that it seems to be drawing right now?
Well, certainly not on the right. Back, I'd say in the mid 2010s, the left started to be upset about Section 230. But it's funny, they were upset because they wanted internet sites to police their content more. And they wanted, of course, things that they deemed to be offensive, things that are politically incorrect, whatever, to also be moderated. So the left had an issue with 230, I think, before the right, but certainly in the last 4 years. And I think it is undoubtedly tied to President Trump, his use of Twitter, and the 2016 election and the allegations of, Russians on Facebook and the rest. All of that really has fueled a intense interest and I think misunderstanding of 230 over the last few years.
So one of the things you mentioned was companies making good faith efforts to moderate their content. It would seem to me that the argument from the right and perhaps from the left as well in certain cases is that, and we're talking now more specifically about social media, Facebook and Twitter in particular, is that they are not making good faith efforts to do so. The argument, I think, from the right would be that they are targeting particularly conservative speech or Republican lawmakers in a way that they're not doing the left. Right. Do you think that does it create a problem for these companies with regard to Section 230?
Yeah, I don't think so for two reasons. One is just the statutory language itself. I'm now a recovering lawyer, but I can't get that out of me. You start with the statute. And like I mentioned before, the statute is really quite clear that it gives absolute discretion to the internet, to the websites for content moderation. And what that means is that really they can moderate anything they want for any reason they want. Because the term objectionable is subjective, means it could be a political reason. And so that I think on the statute alone, that argument fails. But there's a bigger reason. And that is that government efforts to regulate content moderation, even if they are, or especially, I should say, content moderation that is alleged to be politically biased, is really clearly covered by the First Amendment. And so even if you didn't have the sword of Section 230, it's really a stretch to say that the government can go ahead and demand that that websites be politically neutral or whatever without running into pretty serious First Amendment grounds.
It would seem to me that there's somewhat of a correlation here to something we can look at in the past, which was the fairness doctrine that existed for television and radio broadcasting up until, I believe, the mid-1980s when it was repealed. That required, if you were going to have commentary from the political left, you needed commentary from the political right in order to counterbalance it. And the removal of that, I guess the argument would go is that it creates talk radio and the prominence of Rush Limbaugh. It creates cable news in the way that we have it today.
Right.
Is that a good comparison?
Yeah, I think it is. And I think that really is a good segue into, another part of my newsletter on this was really to look at what are the potential implications of imposing a fairness doctrine for the internet. And if you go back to the early 1980s, during the kind of the end of the fairness doctrine era, talk radio, cable news, were very, first of all, they were dead media in general. But beyond that, they were quite tilted towards Democrat or towards kind of the left. Or left of center views. And it was only with the elimination of the fairness doctrine that we saw this kind of vibrant growth of a conservative media ecosystem. And, I think that conservatives would be wise to remember this history when they think that imposing a fairness doctrine for the internet would lead to political neutrality, which in reality, if we have, again, looking back at the fairness doctrine, it seems far more likely that it would end up really in a similar space with kind of a dead space, chilling speech generally, but one that might actually be more tilted to the left than to the right.
I think one of the other counter arguments against Section 230 is that, for better or worse, Facebook and Twitter are essentially either monopolies and or public utilities.
Right.
That you have people who have created a living based off of Facebook or based off of YouTube or based off of their Twitter presence. And then when you have these companies making decisions to demonetize these people, to restrict the access that they have to the platform, to restrict the kind of content that they can share on the platform, that causes harm to these individuals. What do you make of that criticism? And what would it be like I suppose you don't think it's accurate to call these public utilities. What would it be like if we did treat them as public utilities?
So, right. So I think that you'd have a couple problems. I mean, first, let me put it this way. I think you have a couple problems with that argument. First is that, it really ignores that there are large and pretty vibrant alternatives to Twitter and Facebook. So, some of the ones I listed in the newsletter, Reddit has 430 million users. A new one that is growing exponentially is Discord, which has about 250 million users. LinkedIn, 700 million users. TikTok, 800 million users. Now, that one might be going away soon, but Snapchat has 300 million and is another major rising star in this area. And there are others as well. And the point here is that the simple difficulty of moving to one of these other media, or the simple fact that these media are quite good for your business, is really not a reason for regulation or nationalization, because it is not a natural monopoly. And so I think that's the first problem. So I think the second problem with the argument is that, we can look at other industries that have been heavily regulated as utilities, whether it's, water and electricity and those things, or I think a better example is cable providers. And what we see in those utilities is poor customer service, poor quality of service, and a pretty lousy consumer experience. And so I think those individuals who are making good money on Twitter and Facebook right now, but have fears of demonetization, really need to think of the alternative. The alternative is probably not going to be this just, perfectly neutral Twitter and Facebook that we have now. Instead, it's probably going to be something more like Comcast of the 1990s, which I don't know if you lived in Washington, D.C. in the 90s and 2000s, but Comcast was a truly horrible monopolist that did have a kind of state license kind of utility framework. And that's possibly what we could see here. And then, I think the other really important point that people miss is the historical perspective. And if you actually look back at the last 20 plus years of internet companies, what was super popular 10 years ago was not the same company today. I pulled up a hilarious title from 2007 that said, "Will MySpace ever lose its monopoly?" Right? And if you go back, it's not just MySpace, but it's a very dynamic sector. And so to claim that these Twitter and Facebook have a monopoly today and it assumes that they have a monopoly tomorrow, I think is just defies the history of that.
I'm old enough to have had a Friendster account even prior to MySpace. Drill down on the monopoly point for just a moment, perhaps definitionally. Give us a good definition of monopoly, and does Facebook have a monopoly, and if so, in what?
That's a great question. Obviously, it's a bit rich if you take a really strict definition of monopoly, meaning a single provider of a good or service. A single seller of that service. It's pretty comical to say that Twitter and Facebook, which are both, unaffiliated competitors, have a monopoly. Look, I already listed all of the types of competitors that are already out there. But then, like you said, the other really difficult thing is creating a definition of monopoly. Let's just assume they're a duopoly, okay? But it's the poly part that then we're going to get into a problem, because you're really going to have a hard time defining what it is they have control over. First of all, they're giving away most of their services for free. Yes, they get your information, they get your eyeballs, but they're not charging anything, and they're constantly improving their customer experience. But beyond that, if you start saying, well, no, they have a monopoly of information, well, that's not really true, because, for example, we go back to this New York Post story. I could quite easily learn about the story on Twitter and Facebook, and then just open up a new browser tab and go straight to the story. And there's really no legitimate claim that Twitter and Facebook can truly control your ability to get information. All they really do is have a lease on your eyeballs, and they get a good chunk of time for people like me who are very online. But they really can't control your ability to go elsewhere and get the information that you might want or need. And so I think that really runs into one definitional problem. Then in the ad space, look, there's Google and there's a lot of others that allow for the monetization of information. So that I think runs into problems too. And there's also, of course, a lot of other companies out there that allow you to get information that would maybe run into the same type of advertising issue. So I really think it's going to be hard, leaving aside the just simple fact that you have Twitter and Facebook as two entities, leaving aside that there are a lot of other social media kind of chat tech companies out there. I think you'd have a really, really hard time defining what they have a monopoly over to create a case.
I did see a tweet from Missouri Senator Josh Hawley where he was extending an analogy of Facebook being like the only grocery store in town and they can decide whether or not you shop there. But he shared this opinion on Twitter, which I found to be interesting.
Right. And that's a great example of what we're talking about. And I think the other really important thing when we get back to kind of the bias issue is that people seem to close their eyes and ignore the fact that how good conservatives, and of course, President Trump being the ultimate example of this, but how good the online right has been in using social media to get the message out and to bypass, their mortal enemies in the bureaucracy or the deep state, whatever you want to call it, and the media and the fake news and the rest. They've actually been really successful in using social media to push their politics, and they've actually benefited handsomely financially from this as well. And look, I don't deny at all that there are some really sketchy anecdotes out there about Twitter and Facebook executives. And look, they've actually said it, publicly, that there being some anti-conservative bias among those individuals. But there have been studies of whether the media overall is biased in one way or the other, and they really don't reveal any sort of anti-conservative bias systemically. And so I think that's another problem and a hurdle to overcome before we just start jumping into regulation.
I want to back up real quick we've talked about Facebook and Twitter and whether or not they're monopolies and what they might have a monopoly on. You mentioned Google. What if you could talk about that a little? Because I think it would be clearer to define what we might think they have a monopoly on, which is search online. Right. To the extent that nobody says you search anything anymore. You Google it, even if you're doing it on Bing or Yahoo, or right. I guess Ask Jeeves is still around. Could you make a more compelling case for Google in this case having a monopoly? Now, they do a lot of other things, but at least in the search area. And, there are allegations for them as well, manipulating search results to feed alleged political biases that they may have.
Yeah, and so I think that in terms of arguing a monopoly of search, there is a potential for Google to fit that definition by purely looking at the metrics. They have something like 80% of the search volume. The question really is whether that monopoly arose out of anti-competitive conduct or whether it simply arose out of being really, really good. And, the experts seem to, I should say, the kind of free market side of it really seems to think that this is much more about just having a truly dominant search tech. And really something that can't be duplicated. And in fact, the joke is that people use Microsoft Edge to download and Bing to download Chrome so they can start using Chrome and Google. And so Google things. So there really doesn't seem to be much there. The question then, like you said, is, well, if they're manipulating search results, what do you do about that? And, that I think gets really where you'd need hard evidence of kind of a systemic bias. And then you have to ask, well, what's the solution to that systemic bias? And really, I think that again gets to where I don't think there's a really clean answer there. If you turn Google into again a state utility, do you really think you're going to get the quality of search and the quality that we consumers enjoy every day? There was this great study by Stanford's Eric Bjornfilson a little while ago, and I mentioned it again in my newsletter. And they asked individuals to just quantify how much it would cost for you to give up search for a year. And let's face it, that's free Google search. It's not Bing. And it was $17,530. So consumers are really valuing what Google is creating. And we really need to think about whether it is worth destroying that value, or at least hindering it, because of allegations, pretty loose allegations of political bias.
For Google, I would say, perhaps I guess the counter argument would be that they rose to prominence because they did build a better mousetrap, that using Google as a search engine was superior to using Yahoo or Ask Jeeves of any of those things at the time. Right. But that perhaps the anti-competitive practices would be the way that such a suite from them is deployed, that you not only have search, but you have it tied to your Gmail email address. And YouTube is a Google product, and Google Analytics is the top platform for analyzing web results, and publishing is done so much on Google, and news syndication is done so much on Google, that they maintain it by sucking you in with how good the search engine is. But this suite that's deployed over all these different things keeps you, it's breaking it up to so many other things, disincentivizes you from wanting to do so, and keeps you with Google, whether or not it's a good product, I guess.
Yeah, and I think that then you run into a question of whether they truly have a dominant presence in those other areas. And I think that case falls apart pretty quickly when you look at all of the different search engines out there, when you look at all of the different mail platforms. Of course, there's Apple and the entire suite of iOS products and the rest. And just because just because consumers might be a little lazy, doesn't mean that you have a monopoly that requires regulation. I mean, quite honestly, I don't really consider the Gmail app to be good, really good. I do use it out of convenience because I've had a Gmail account for like 20 years, and what am I going to do, really? But at the same time, when I want to do real work, I use Outlook, and again, that's the other 900-pound gorilla in the room is Microsoft and its dominance in the kind of Office suite as well. And so there's really not, I don't think just because we're kind of lazy and we're okay to use inferior products is a reason to say, we got to break up Google.
Let's bring it back to specifically Section 230 here. You have various calls for it to be repealed. So I guess two-part question. One, what would happen if it were to be repealed? And two, are there any quote-unquote reform proposals that are floating around out there that wouldn't repeal it but would change it in a way that at least seeks to address some of these concerns or issues that people are raising about it now?
Right. So let's start with just a basic. Well, I think we can put repeal and kind of a Hawley-esque reform into the same basket. So for those who don't know, Senator Hawley wants to essentially set up a certification process where you have to prove to the FTC, the Federal Trade Commission, that you are politically unbiased, quote unquote. And if four of the five commissioners agree, then you can have Section 230 protection. I think that's honestly quite might as well be as bad as a repeal. But in general, there's a lot of potential harms that can come from these types of really drastic changes to 230. I mean, first, which I as a libertarian I care about, is just putting the government in charge of more online speech. I mean, any way you slice or dice it, whether it's going to be through the FTC or through the courts or whatever, you're going to have the government determining more of what is appropriate online content. Because even if you are trying to claim neutrality still requires judgment, and that's going to come from the government. And that strikes me as really a problem. But from purely a strategic perspective for conservatives, again, it strikes me as odd to want to put the government in charge of, or at least as a regulator of political speech again. The next, I think, quite a big one is lawsuits. I think you would see a lot of lawsuits as, there is so much content that is not in the black or the white. The black is child pornography, for example. I mean, clearly illegal or clearly problematic content, threats against people's lives. Okay, that's another good example. Or in the white category, right? That's a birthday, picture of my daughter's birthday on Facebook. So, but there's so much gray in there, and moderating that gray would become part of the business model for these companies. And so you would see, I think, any sort of gray would be litigated. Litigated by, I think, some good faith actors, people who really think they have been moderated inappropriately or in a biased manner. But I think there also is a huge potential for just deep, litigants going after deep-pocketed big tech. And, as I joked, you'd have a newly empowered plaintiff's bar for internet speech. That strikes me as as a former lawyer, I can say this. Before I probably would have had, been disbarred, but now, that strikes me as a really bad idea to have a plaintiff's bar for that purpose. But next, because of that litigation threat, I think you'd have less speech overall. Companies are not going to take the risks of all of that litigation, of government regulation, of all of those things, if they don't have the type of protections that 230 provides them. And so what that's simply going to mean is you're not going to have Yelp reviews. You're not going to have, you might not even have a Twitter or a Facebook. If you really had kind of a true repeal of 230, you'd have less Craigslist ads, and all of those types of things that we enjoy in third-party content would shrivel, if not disappear entirely. And then, of course, any sort of long delays in or strict regulation of content. Let's say the companies say, well, it's our business model, we've got to stay in business. Well, that's going to simply discourage consumers from using those services. And so, look, I'm not going to want to wait a day for my tweet to get posted. That kind of defeats the purpose of that media. And so I think that, you might think that's okay, right? Twitter's just a bunch of idiots making, dumb jokes or whatever. But the thing you have to remember again is that this wouldn't just apply to Twitter and Facebook. It will apply to Amazon and Yelp and the rest, and all of those types of third-party content from which we derive real value. And not just value for you and me as consumers, but value for researchers who use social media and other things for really cool real-time economic research. All of those things would go away, and that I think would be bad. Another one that I think is pretty obvious, it would hurt consumers. I mentioned we all value Twitter, Facebook, all this free tech, quote unquote free tech. We value that. Well, that of course would be diminished. You'd also see small businesses hurt, right? Because, look, Google has an army of lawyers and they can handle the lawsuits and the regulators and the rest. Small businesses can't. And there's good research showing that investors wouldn't be as willing to invest in tech companies and online platforms if they had this litigation risk, if they didn't have Section 230 protections. So that slows economic growth. It slows innovation. That's all bad. And then finally, again, like the fairness doctrine, like campaign speech or campaign donation contribution limits and the rest, campaign finance limits, you empower legacy media. Right. So, these are the folks that they would not really have to worry about or need to circumvent traditional media because they are traditional media. And again, I think that comes down on, that would actually end up hurting conservatives much more than it helps them.
Facebook, Twitter, if you were to offer advice to them for how they should approach their content moderation so as to avoid, or at least attempt to avoid, some of the calls for the repeal of Section 230 and then all the consequences that would flow from that. What advice would you give them?
Well, as I noted in my newsletter, I think they are in an unwinnable position because if it were me, if I weren't running a business, if I weren't running their business, I would have a very, very liberal moderation policy. In other words, pretty much anything that wasn't illegal, I would allow, simply because I think that when you start going down this moderation rabbit hole, these types of problems are inevitable. The problem they have is that people are demanding moderation. And, certainly from the left, I've heard this a lot. Oh, it's only the left demanding moderation. Well, that's not really true, because when you get away from the clearly kind of the political correct side of demands, there's also a lot of demands related to whether it's defamatory content or things that are just kind of objectionable or profane or whatever. I mean, you pull in a lot more people who are demanding moderation. And then, of course, there's the ad buyers and the companies, and they're demanding moderation too, because their customers don't want to see whether it's profane content or whatever. And so once you then open the door to moderation, once you then say, okay, it's not a black and white standard of illegal versus not, that is really going to create, like I said, an almost unwinnable situation, given the sheer amount of data we're talking about. I mean, you're talking about millions and millions of bits of information posted every day, and armies of people trying to moderate this stuff and failing miserably to do it. And so I think that my only advice would be, given that dilemma, and given that I think tensions are inevitable, my only advice to them is absolute transparency. Really being as open as possible about what went right, about, well, first of all, your standards, here's what we're going to do, and applying it really robotically. And then trying desperately to provide transparency when things go wrong. And I think they fail pretty miserably on that last point. You see, whether it's Jack Dorsey or Zuckerberg or wherever, when they make a mistake, they go, oh, we messed up. But you don't actually then get into the weeds of how they messed up, of what really happened. And I think that breeds more conspiracy theorizing. I'm still pretty much in the camp that these guys are more incompetent than they are malicious, but we don't know that. And that allows for people to think the worst. So my advice would be, objective standards and absolute transparency. And unfortunately, I don't think we're there right now.
To conclude here, I want to ask your personal opinion on something. So you mentioned, being a person who's very online, I am too, to a great extent. I follow you on Twitter, and people get various degrees of joy out of that whole experience. But I think you couple two things together here. One, we had the memories of the 2016 election, stories of Russian interference and fake news that we've been talking about for the last 4 years. And really for the last, at least 10 years, I think I joined Facebook in 2005, 15 years or so. We've been living with these social media platforms that we're still really coming to understand how to live with them, how to use them in a way that actually feeds our happiness and doesn't feed kind of some of the darker elements of our human nature. Yes. People lash out on Twitter and social media. There's the keeping up with the Joneses problem of people curating their lives to seem even better than they actually are, and the impacts that it has on people. Yeah. How much of you, in your opinion, do you think this is born of a combination of that moral panic that came from the 2016 election and from some people's, or at least not a general sense of unhappiness with social media and how it makes us feel?
No, I think there's some truth to that. As I've said elsewhere, that being online is really like any sort of, junk food or anything that gives you that dopamine rush, right? It requires discipline, and it requires eternal vigilance of sorts. And I do think that it's easy to get carried away, just as it's easy to go to McDonald's every day. And it does require individuals to exercise personal responsibility and to exercise discipline over their use habits, and quite frankly, to mute and block people liberally. It is simply not worth it, and you have to kind of learn that. I was kind of going down that road of being kind of too online and hyper aggressive, and I realized you really need to take a step back from that. And I think that, so first, there's a really key element of that is an individual and personal responsibility for maintaining a presence, for being online. That said, because I think that feeds into my answer to you, is that I do see kind of an issue here, but not one that requires a government solution. I think it's one that really, like any sort of social or any sort of vice, if you even want to call it that, it just simply requires our own individual and personal responsibility. And if we practice that more, if we were a little more hesitant to share things that might fit in our cognitive biases just a little too comfortably, if we're a little quicker to not respond to someone, or if we, schedule our screen time just like we schedule it for our kids, you could solve, I think, a lot of the issues that we're seeing that people feel with social media right now. And I think you'd avoid all of the sorts of problems we'd have by getting the government involved.
Scott Lincicome is an international trade attorney, a senior fellow in economic studies at the Cato Institute, and a visiting lecturer at Duke University Law School. He also writes the newsletter Capitalism for the Dispatch. Scott, thanks so much for joining us today on Act in Line.
Oh, my pleasure. Thanks for having me.
As always, thank you so much for listening today. Our team loves putting this show together for you every week, and it's so encouraging to hear from our listeners. Feedback is incredibly important to us because it lets us know what you like to hear more of, including the kinds of topics you're interested in most. If you have comments, feedback, or ideas for a show topic or interesting guest, you can reach our team at actinline@acton.org. Until next week, for Act in Line, I'm Eric Cohn.